Thank you very much for your presentation. I would like to ask
Su presentación.
the State of Canada to make their response also for 20 minutes.
Thank you. Thank you very much. Good morning, everyone. My name is Jane Arbor, and I am counsel for the Government of Canada. With me today are Ambassador Alan Cullum, directly to my right, Douglas Janoff, also from the Permanent Mission of Canada to the Organization of American States, Mr. Frank Soda, a Director of Negotiations for the Government of Canada, and my co-counsel, Dan Moore. Canada's oral presentation, like its written submissions, presents the views of both the Government of British Columbia and the Government of Canada. In the time available today, it is not possible to address all the issues raised by this petition. Canada therefore continues to rely on all its written submissions. The petition brought by the Hulquminum Treaty Group raises issues that implicate negotiations under the BC Treaty Commission in Canada. This petition, which examines the rights of the HTG under the American Declaration on the Rights and Duties of Man, also affects the interests of many other First Nations and many non-Indigenous persons in British Columbia. This petition raises issues of great importance to all Canadians, the reconciliation of Indigenous rights with the sovereignty of the Canadian state. The BC Treaty process is a process of confidential, interest-based negotiations. The confidentiality of negotiations, which is so important to creating a space in which settlements can be crafted, creates a certain difficulty for all of us, as it is not possible to give the Commission a full understanding of the state of play at the HTG treaty table. While Canada cannot discuss specifics, the parties to the HTG treaty table have recently met and have resumed negotiations. Another preliminary point for Canada is in regard to the amicus briefs that have been filed in support of this petition. Canada has not attempted to address directly many points raised in these briefs. Much of what is raised there is not relevant to the situation of the HTG. More disturbing, however, is the presence of misinformation and hyperbole in these briefs. Canada asked the Commission not to give undue weight to untested and therefore questionable statements contained in these briefs. The focus of Canada's presentation today is certain specific aspects of three broad areas of inquiry: the functioning of the BC Treaty process, the process of litigation in Canada, and the allegations in the petition. Mr. Soda, who is the Government of Canada's Director of Negotiations for the Vancouver Island region, the area we're talking about, will address aspects of the BC Treaty process.
Thank you very much, Jane. Mr. President, members of the panel, Hulquminum chiefs, and other representatives, modern treaty making in Canada is a big undertaking. Just take a look at the larger of the two maps which were provided to you. This map shows that more than 100% of the landmass of British Columbia is claimed by First Nations. The aim of the BC Treaty process is a negotiated resolution of the outstanding First Nation land claims in British Columbia. Negotiations under the BC Treaty process are comprehensive, complex, and dynamic in nature, and they must address the rights and interests of the parties to the treaty, as well as other First Nations and non-Aboriginal members of Canadian society. Each of the agreements negotiated under the BC Treaty process has required significant effort and dedication from each of the parties to ensure the negotiations provide win-win results that balance the interests of all Canadians. Modern treaties in Canada are not historic treaties. They contain many more components. Modern treaties in Canada are comprehensive. They're comprehensive documents that set out First Nations treaty rights and benefits. They include self-government, culture and heritage, fisheries and wildlife harvesting, environmental assessment and management rights, and of course, they also include land and cash. Canada refers the Commission to the Manolf Final Agreement. This is the most recent treaty concluded. For the breadth of issues and negotiations negotiated by the parties, you will see in the table of contents of this document the scope of a modern treaty. The text and appendices contained contained the details that needed to be worked through in order to reach a treaty with the Manaus First Nations. The Manaus Treaty provides the 5-member First Nations with a population of approximately 2,000 people with land and cash valued at approximately $500 million, $500 million. Under the treaty, over 24,500 hectares of land on Vancouver Island were transferred in fee simple to the Manaus First Nations. Canada notes for the Commission that private lands were purchased for inclusion in the Manaus Treaty. Canada asks the Commission to appreciate that while modern treaty making in Canada takes time, settlements are being realized. All the parties have learned that it does take time to achieve a comprehensive and enduring settlement. Even so, there is momentum at many negotiating tables, including the Hulquminum table. On October 12th of this year, the BC Treaty Commission released its annual report, which is the red booklet provided earlier to you. The report refers to 60 First Nation groups which have engaged in this voluntary process since 1992. Of the 42 First Nations which are currently actively negotiating, 15, or more than 1/3, are in advanced negotiations. That means that they are nearing conclusion of an agreement in principle, nearing conclusion of a final agreement, or in fact have concluded a final agreement. I would like now to address the specific issue of the size of the negotiation loans and the timing of the repayment of these loans. When the BC Treaty process was established, First Nations, British Columbia, and Canada agreed that loans and contributions should be made available to First Nations in order to create a level playing field amongst the parties. An annual funding budget is established by Canada and British Columbia, which comprises up to 80% loans and 20% non-repayable contribution funding. The independent BC Treaty Commission is responsible for allocating this annual funding to individual First Nations based on the First Nations' proposed negotiation work plan. Neither Canada nor British Columbia is involved in the decision of how much each First Nation receives from the BC Treaty Commission. Loans under the BC Treaty process are repayable upon successful conclusion of a final agreement. This repayment is offset from the cash component of a settlement. If a First Nation voluntarily chooses to withdraw from the treaty negotiation, the loan becomes payable. However, to this point, Canada has not initiated collection measures in such circumstances. Another specific issue which arises due to the fact that modern treaty negotiations are multi-year initiatives is what happens in the interval during which negotiations proceed. Time does not stand still for First Nations involved in treaty negotiations. The governments of Canada and British Columbia provide significant benefits to First Nations both within and outside the treaty process. For example, Canada provided annual funding to the HTG member First Nations last year in the amount of approximately $54 million. Federal funding for all First Nations includes money for economic development, education, governance, healthcare, housing, income assistance, infrastructure, and public works. This funding is not alone. It is a cash transfer to First Nations so they can provide programs and services to their members living on their lands. The government of British Columbia engages First Nations on matters that fall within provincial jurisdiction, whether they're taking part in the BC Treaty process or not. British Columbia has and continues to negotiate a range of agreements to address First Nations' varied interests and make progress towards reconciliation while recognizing that one size does not fit all. These agreements include, but are not limited to, 1. Incremental treaty agreements that flow treaty benefits, including land, to First Nations in advance of the conclusion of a treaty. 2. Agreements that provide First Nations with a share of government revenues generated from resource development in their asserted traditional territory. 3. Agreements that protect areas of cultural significance. And 4th, agreements that provide for First Nations participation in resource management decisions on Crown lands within their asserted traditional territories. As treaty negotiations are being pursued, a First Nations' asserted rights are taken into consideration by the federal and provincial governments through a consultation and accommodation. Governments in Canada consult, and where appropriate, accommodate First Nations on matters that may adversely impact their interests or rights. Canada recognizes that consultation is important for good governance and sound policy development and decision-making. We have strong consultation processes in place. Canadian court decisions have stated that such processes are a matter of law. So the result is, if Hulquminum does not want to pursue the treaty process, they don't have to. They can pursue the protection of their asserted rights through litigation in the courts, or in the event that major activities are taking place on Crown lands, through consultations and accommodation processes. I would like to conclude my comments by quoting Sophie Pierre, Chief Commissioner of the BC Treaty Commission's 2011 annual report, the red booklet in front of you. Treaties will bring a $10 billion cash injection, new investment in jobs, and a better future for First Nations and all British Columbians. Ultimately, it is the responsibility of the governments of Canada, British Columbia, and First Nations to answer the question: how can we realize a significant return on the investment we have made in treaty making in British Columbia? We believe the answer is straightforward: to recommit to treaty making, ratify final agreements and agreements in principles, and resolve the overlaps on shared territory. Success in these areas will ensure there is a return on investment the parties have made in the BC treaty process over the past 19 years. Thank you, Jane.
Thank you, Frank. The governments of Canada and British Columbia remain committed to participating in the BC treaty process, as negotiations offer the best avenue for resolution of the outstanding land claims in British Columbia, that also allow the parties to address so much more than just the question of the land. Canada recognizes, however, that not all First Nations want to negotiate a settlement at this time. Another option available to all First Nations is to turn to the courts for a judicial determination of the extent of their asserted Aboriginal rights. In 1982, during an important time of constitutional renewal for the Canadian state, a powerful provision for the protection of the rights of Indigenous peoples in Canada was placed in our Constitution. Section 35 of the Constitution Act 1982 protects both Aboriginal and treaty rights for the First Nations of Canada. Aboriginal rights are the rights of the Indigenous peoples of Canada that are described in our common law. Since 1982, Canadian courts have been developing tests to describe these rights. Aboriginal rights can encompass a variety of things, including land ownership or Aboriginal title, various rights to the use of land for hunting, fishing, gathering, cultural and spiritual practices, various rights not tied to specific land, and governance rights. Many existing Aboriginal rights, however, are inchoate, not yet fixed in law for the particular First Nation, because the courts have yet to be asked to determine if many given First Nations in fact have the rights they claim. Treaty rights are those rights of the Indigenous peoples of Canada that have been set out in a treaty between the First Nation and the relevant governments. These rights can be found in both historic and modern domestic treaties. The content and scope of treaty rights are determined by the parties. Modern treaties in particular contain a wide variety of rights. In order to describe the impact of the courts in Canada for the protection of Indigenous rights, and therefore the viability of the litigation option for First Nations, Canada notes for the Commission that litigation on Indigenous rights in Canada can address either domestic treaty rights, or the duty to consult Indigenous peoples concerning their treaty or Aboriginal rights, or the content and scope of their Aboriginal rights. Canada's submissions have attempted to explain that First Nations who have pursued litigation have a good record of success in respect of the litigation of their treaty rights or the challenge to the adequacy of government consultation. Canada's presentation today focuses only on Aboriginal title litigation, litigation in which a First Nation seeks a determination by the Canadian courts of the scope of its asserted rights to the ownership of land. The efficacy of Aboriginal title litigation in Canada is highly relevant to the outcome of this petition. The HTG are alleging that Canada is violating its property rights under the American Declaration. The HTG also claim a large area of land on Vancouver Island as its ancestral territory.